Ladies and gentlemen, I'm Professor Evelyn Welsh. I'm the Vice Principal for Arts and Sciences here, and it's my enormous pleasure to welcome you on behalf of King's College to this inaugural lecture. It's a great honour to introduce Professor Takis Tridimas, who's been a colleague of mine both in this institution and in the past at Queen Mary University of London. He's here at King's as Director of the Centre of European Law in the Dickson Poon School of Law. Takis, as many of you will know, and I think the turnout this evening is testimony both to his eminence and to his capacity for friendship there, is a leading scholar in the field of European Union law. His work as a barrister covers the whole spectrum of EU law and the European Convention of Human Rights. He's one of the most frequently quoted authors by Advocates General of European Courts of Justice and on matters of EU law by English courts. Professor Tridimas specialises in public law and judicial review, competition law, company law, banking and financial services, commercial law, and conflict of laws. And there is no danger that he will run out of things to do in the decade to come there. Since 2008, he has been advising both the banking sector and state organisations on matters relating to financial and to the Eurozone crisis. He also served as referendaire law clerk to Advocate General Sir Francis Jacobs at the European Court of Justice between 1992 and 1995. He was senior legal advisor to the EU presidency in 2003 and chairman of the committee set up by the EU Council of Ministers to draft the Treaty of Accession of 2003 there. And indeed, this role involved conducting the legal negotiations and drafting the accession treaty by which 10 new member states joined the EU. And the accession treaty itself was signed on the 16th of April 2003. Professor Tridimas is also the Nancy A. Patterson Distinguished Faculty Scholar and Professor at Pennsylvania State University. He is, or has been, visiting professor in many universities, including the College of Europe, Bruges, Sciences Po, Université Panthéon-Assas, Paris 2, and the University of Geneva. He is barrister at the Matrix Chambers, and it is a privilege that he is also ours here at King's there. This evening, we are very much looking forward to his inaugural lecture, which will be followed by a vote of thanks from the Dean of the Faculty of Law at King's College London, followed then by drinks in chapters, which is just upstairs there. Ladies and gentlemen, can I please invite Professor Takis Tridimas to come up to the podium to deliver his inaugural lecture, European Rights and European Wrongs. Takis.
Vice Principal, distinguished guests, ladies and gentlemen, I am enormously honored by your presence here this evening. I am very grateful to the Vice Principal for her kind words, although I don't think I deserve them. It is a privilege to be a member of the law school at King's. It is a distinct honor and a great responsibility to be at the helm of the Centre of European Law. The Centre is very fortunate to enjoy the unfailing support of the College, of Dean David Curran, its advisory board, and indeed of all of my colleagues and all the students. I am addressing you this evening with great pleasure, but given the audience, also with some trepidation. I came across a lecture by Professor J.J. Park. He was one of the very first professors at the law school at King's. He wrote this lecture in 1831, and he states, he extols the virtues of a good law professor. And he mentions the following. He says, a good law professor must throw new light to the study and the science. He must open new interests. He must carry the law beyond the condition in which it is to be found. He must, in short, keep the minds of his class in a state of activity, vivacious activity. This seems to me to epitomize what we strive to achieve in the scholarly community, what the law school and King's is all about. The title of my lecture is European Rights and European Wrongs, but it is not my intention to present you with a list with what, in my view, are good things and bad things about the European Union. Far from it. My intention, rather, is to explore selectively the rights discourse of European Union and the contribution of the judiciary, in particular the European Court of Justice, to the development of European Union law. My starting point is that ambiguity is an inherent ingredient of any constitutional order, and that law is primarily about courts and the way that they apply it. We all agree on principles, but not all of us agree on outcomes. We all think that freedom of expression or the right to privacy are good things, but not all of us derive the same conclusions from these principles. And it is the job of the courts, the job of the judges, to transform principles into outcomes. They are the agents of the Constitution. Allow me here to borrow two tales from ancient Greece. Aeschylus teaches us the torment of Prometheus. Prometheus steals fire from the gods and gives it to the people. Aeschylus juxtaposes the powers of the gods on the one hand with the intelligence of the humans on the other. A democratic constitution juxtaposes the powers of the politicians vis-à-vis the internalized notion of justice that the courts apply. Like Prometheus, judges share the distress of responsibility that comes with intermediation. The second tale comes from Antigone. In Sophocles' seminal tragedy, Antigone personifies the enduring concept of the substantive rule of law in defiance of positivism. She posits that law exists apart from and beyond the political organs of government. One may find echoes of this a substantivation of the rule of law in the case law of the European Court of Justice. The court has, as I shall try to show, an Antigonian outlook. The influence of the European Court in the development of EU law has been extraordinary, indeed, in many respects, unique in the history of national and international legal orders. And I think there is good reason for that. Judicial protection is central to the integration through law paradigm. The transition of the European communities from an international organization to a new form of governance was effected through the dismantling of the nation-state's monopoly in granting rights. The early judgment of Van Gen and Luce signaled rights creation at supranational level, thereby commencing a process towards the dispersal of political power and the strengthening of the role of the judiciary. Allow me to explore briefly three things: the relationship between the European Court of Justice and the national courts, the protection of fundamental rights in EU law, and the theme of judicial activism. And without wishing to give it all away, in short, my views are as follows. The European Court of Justice has done much to enhance the protection of fundamental rights. This is commendable, but it has occurred as part of a centralized constitutional model which poses risks to personal freedom and the citizen. Secondly, I don't think it is correct to question the legitimacy of the European Court of Justice. I don't think it is correct to suggest that it engages in unwarranted judicial activism. It should rather be recognized that the ECJ builds common law constitutionalism, and its performance should be judged by reference to a set of concrete criteria which I shall try to suggest. Incidentally, my first visit to the European Court of Justice remains the most dramatic. It occurred a long time ago. I had just been appointed to my first job as lecturer at the University of Birmingham, and my task was to accompany a group of students to the court. At that time, president of the court was the late Lord Mackenzie Stewart. He was an extremely fine lawyer and a wonderful person, and he offered us lunch. For some reason, which still escapes me to this day, the student that sat next to him thought that the person sitting next to her was not the president, but the president's driver. She wanted to engage in conversation and thereby followed an exchange which could have been taken straight from any play of the theatre of the absurd. Harold Pinter would have been very proud of it. She says, do you drive a lot? No, not really, responds the president. So she's surprised. How come the driver doesn't drive? So she says, but to do your job properly, you should be driving all over Europe, surely. The president says, actually, I have a driver. Now, that shows you how bad things can go if you begin from the wrong premise, because she now wonders how come the driver has a driver of his own. Clearly, even by the standards of profligacy of the European Union, this is too much. So she says, oh, you have a driver. How does that work? And the president responds, well, the driver drives, and I usually sit at the back. And she says, and what about the president? And what about the president? He responds. You appreciate by this time I am sitting at the opposite side of the table, lamenting the premature end to my career, confident that my first visit to the court will also be the last one. But the confusion was resolved. Lord Mackenzie Stewart was an extremely unassuming person, and he resolved the misunderstanding. So, coming back to the three themes, let me begin with the relationship between the European Court of Justice and the national courts. Although the development of European Union law is the result of the interaction of many political and institutional actors, no other relationship is perhaps as important as that between the ECJ and the national courts. Their interaction is dialectical, it is full of circumspection and deference, albeit occasionally tense and based on an incomplete and somewhat unstable political bargain. The legal order of the European Union is rights-based and owes as much to political negotiations as to the adjudication process. This is partly by treaty design, but mostly self-generated by the judiciary. The EU legal system is based on a decentralized system of justice, where national courts are the primary venue for the accession of EU rights. The preliminary reference procedure enables a national court, and sometimes requires a national court, to make a reference to the ECJ on the interpretation or the validity of European Union law. This reference procedure creates paths of dependency which elevate the national courts to key interlocutors. But treaty design did not predetermine the constitutional character of the interaction, nor the way that it would develop. Through the articulation of the principles of primacy of EU law and direct effect, the court began to create constitutional law by the common law method, an expression that I owe to Professor Posner, a process that national courts embraced and encouraged, albeit with different degrees of enthusiasm. It seems to me that national courts are the most important interlocutors for two reasons. First, their cooperation is essential for the initiation of the preliminary reference procedure and also for the application of the rulings of the European Court of Justice. Also, crucially, they provide the most effective oversight over the court's activist tendencies. If the European Court of Justice were to overstep its powers, member states could envisage a number of measures, but not all of them would be effective. In fact, I would submit that all of them would be subject to important limitations. They could, for example, change the judges, or change the treaty and curtail the jurisdiction of the court, or even reduce judicial salaries. But all these measures would be difficult to agree on, they would take time to implement, and they would be uncertain. By contrast, if national courts were to withdraw their cooperation, that would have a more immediate and direct impact on the European Court of Justice. Viewed in that perspective, a successful relationship between the court and the national courts is the key that unlocks the integration door. I hasten to add that not all cases that the ECJ hears are of constitutional importance. Allow me to give you two examples. A case decided back in 1994, Neckermann, had to do with the importation of pajamas from China to the European Union. But these pajamas were very nice, were very posh. So the customs authorities thought they cannot be just pajamas. It's not worth wearing them only to turn off the light and go to bed. They're so nice, you really want to have time to see them. So it classified them as leisure wear. So here is the problem before the court as explained in paragraph 2 of the judgment. Those garments, which had been declared as pajamas, were reclassified by the German authorities as upper garments and trousers, and in one case, as ensemble, with the result that a higher rate of customs duty was charged. So this raised the fundamental question of what is a pajama. In particular, the National Court asks, is it sufficient in order for garments to be classified as pajamas that they may, in addition to other uses, also be worn in bed? Or do they need to be worn exclusively in bed? And the court engages in some good old statutory interpretation. The objective characteristic of pajamas, the court says, which is capable of distinguishing from other ensembles, can be sought only in the use for which pajamas are intended, that is to say, to be worn in bed as nightwear. If that objective characteristic can be established, the fact that it may also be possible to envisage another use for the garments will not preclude them from being classified for legal purposes as pajamas. It follows that for a garment to be classified as pajamas for customs purposes, it does not have to be solely or exclusively meant to be worn in bed. It suffices if that is the main use for which it is intended. Then some years later, the court had to grapple with some difficult issues about the exportation of meat from Denmark to Germany. And effectively what happens in this case is that a group of Danish slaughterhouses seeks compensation from Germany for restricting the importation of uncastrated male meat coming from uncastrated male pigs from Denmark. EU law prohibits the marketing for human consumption of meat which gives off a pronounced sexual odor. It requires that the slaughterhouse must be able to guarantee by means of a recognized method that carcasses giving off a taint must be detected. Okay, what happens is that the Danes have invented this method of detecting levels of odor, and all slaughter lines, we read in paragraph 12, were fitted with scuttle measuring equipment to enable meat affected by the taint to be identified and rejected. But that would not do for Germany. The Federal Republic of Germany stated that only one method, Professor Claus's modified enzyme immunoassay, was recognized as a specific method for identifying the relevant substances, and therefore the meat could not be transported in Germany. German professors are very powerful people. So Professor Claus had the only method that would permit for free movement of goods. In any event, the court found for Denmark in that case, but I think the case serves to illustrate that not absolutely every case that comes to the European Court of Justice raises profound constitutional questions. Now, the relationship between the ECJ and the national courts occurs in the shadow of a centralized constitutional model. This has some strong federal elements. It is powered by the principle of primacy and the principle of direct effect, and includes, among others, the following features. First of all, an expansive interpretation of EU competence, an expansive application of human rights, a relatively narrow conception of national constitutional autonomy, and a strong reliance on the principle of effectiveness. Allow me to illustrate a couple of those points. One of the main ways in which the European Court of Justice has contributed to the integration through law paradigm has been through an expansive interpretation of EU competence. The court has been activist, if you wish, by being passive in the exercise of its power of judicial review of EU measures. A prime example is provided by the interpretation of internal market harmonization powers. Article 114 of the Treaty on the Functioning of the European Union enables the European Union to harmonize the laws of the member states in order to facilitate the establishment and functioning of the internal market. The distinct feature of Article 114 is that it provides a non-sectoral transversal harmonization power, which to a good extent is value neutral. The European Union has to satisfy the court that there are differences among the laws of the member states which create an obstacle to interstate trade. Once this condition is fulfilled, the EU can harmonize national laws and retains enormous discretion on the substantive policies of harmonization. This has enabled the European Union, for example, to pursue health protection considerations, even though it lacks legal basis to harmonize national laws for public health. There appear to me to be a number of issues here, whether the test of direct impact on trade is appropriate, what is the standard of evidence required, and what is the significance of the principle of subsidiarity. Whilst the test of direct impact is in itself appropriate, the absence of economic analysis in the case law, the low threshold of proof demanded of the European Union legislature, and the virtual absence of subsidiarity control result in the regulatory empowerment of the Union. The dice, in other words, is heavily loaded in favor of EU intervention. The case law has essentially elevated the competence of the EU under Article 114 to an existentialism issue. Either the EU is empowered to intervene, or there is no point in having a European Union at all. A recent example of this approach is provided by the case of United Kingdom versus Parliament and Council, where the European Court of Justice sanctioned the use of Article 114 as a legal basis to grant an EU agency power to adopt decisions addressed to specific financial institutions. The power to adopt specific decisions appears to me to go well beyond the harmonization of national laws. The test that the European Union needs to satisfy under Article 114 appears to me to be less onerous than the test which Congress needs to satisfy to enact federal legislation under the Interstate Commerce Clause of the United States Constitution, as explained in a judgment delivered in 2012, where the Supreme Court had to examine the compatibility of the Affordable Care Act, the so-called Obamacare legislation, with the United States Constitution. In effect, what happens is this: the European Court of Justice follows a double standard of judicial review. It applies a low level of scrutiny, where it reviews the scope of EU powers, but a much higher standard where it reviews the compatibility of EU and national legislation with fundamental rights. My point is simple: whilst robust standards for the protection of fundamental rights are to be welcomed, they are not by themselves capable of guaranteeing citizen protection if the EU is recognized a very wide competence. In the same way, the European Court of Justice has paid, I would say, measured a respect to the national constitutional traditions. This is illustrated by the judgment in Meloni, which concerned the compatibility of Article 4 of the framework decision on the European arrest warrant with the right to a fair trial. Article 4 provides, in essence, that if a person convicted of a criminal offence in absentia was properly informed of the trial and chose not to appear, the executing judicial authority, i.e. the person from where his extradition is sought, cannot make the person's surrender, the person's extradition, subject to there being an opportunity for retrial, even if under its national constitution that right exists. The European Court of Justice held that Article 4 was compatible with the right to an effective remedy and the right to a hearing, and it foreclosed the possibility of a member state refusing to execute a warrant on grounds that the standard of protection of the right to a fair trial is higher under national law. The judgment in Meloni appears to me to project an inclusive, centralized approach to the protection of fundamental rights, placing the Charter of the EU Charter for the Protection of Fundamental Rights at the apex of the edifice. I think this interpretation of Article 4 is correct. Behind, however, the clinical language of the court and the cold logic of primacy lies a choice of a centralized constitutional model where the capacity of national constitutional norms to protect the citizen is impaired. The problem does not lie, in my view, in the Meloni judgment, which I think is correctly decided, but in earlier judgments where the European Court of Justice recognized competence to the European Union to adopt the European arrest warrant in the absence of harmonization of substantive criminal laws. It's also interesting, again, if I can borrow from American jurisprudence, to contrast it with a judgment by the Supreme Court of Wisconsin, where that Supreme Court held that the right against self-incrimination, as protected by the Constitution of Wisconsin, went further than the right as guaranteed by the Constitution of the United States. The court stated the system of federalism envisaged by the United States Constitution tolerates such divergence where the result is greater protection of individual rights under state law than federal law. I am aware that there are differences in the context and in the two cases which suggest a more nuanced reading of the two cases than I have suggested, but nonetheless they appear to me to provide an interesting contrast. Despite this critique, I think it is correct to say that the European Court of Justice has done a lot to protect fundamental rights, often providing a higher level of protection than that guaranteed by national law. Since the entry of the Treaty of Lisbon into force, the European Union Charter for the Protection of Fundamental Rights has acquired binding force. In what ways has the coming into force of the Charter affected the protection of fundamental rights? First, it seems to me there is no doubt that it has increased their resonance. A litigation on fundamental rights has increased, and so has the number of cases raising issues before the ECJ. Secondly, although the Charter has not had a major impact on the methodology of the court, which continues to be centered on the principle of proportionality, it has had a mild, albeit noticeable effect on its reasoning. The judicial inquiry has become more structured, and overall there has been a somewhat higher degree of judicial scrutiny in assessing compatibility of EU law and national measures with the Charter. This, I think, should not be exaggerated. It should be recalled that some of the most activist judgments on fundamental rights, such as the judgment in Caddy or Carpenter, predate the coming into force of the Charter. Also, it is unclear, indeed I would submit doubtful, whether cases where post-Charter cases where the court invalidated EU measures would have been decided on grounds of incompatibility with fundamental rights, would have been decided any differently if the Charter had not existed. Perhaps the most important impact of the Charter is that it has encouraged and provided added legitimacy to the federalization of the EU legal system and the shift of the integration paradigm from a union centered mostly on the internal market to a union covering broader aspects of economic, social, and political life. It has reiterated and enhanced the role of the European Court of Justice as the Supreme Court of the Union, which seeks to provide a one-stop forum for the protection of fundamental rights. This, in turn, defines the relative position of the court vis-à-vis national constitutional courts and the Court of the European Convention of Human Rights, the Strasbourg Court. Effectively, what the European Court of Justice is doing by providing a high level for the protection of fundamental rights is preempting the need for citizens to go to Strasbourg. Why go to Strasbourg if you can get what you want from Luxembourg? I think the court's presence in the field of fundamental rights can be illustrated by reference to three areas: the right to judicial protection, the principle of equal treatment, and the right to family life in conjunction with the right to the protection of personal data. These are the areas where it appears to me the court has been particularly active in recent years. Let me then look a bit at the third topic that I mentioned at the beginning of my lecture, judicial activism. Is it correct to say that the European Court of Justice engages in judicial activism? I think we first need to define the term. The term judicial activism is an overused expression, often employed loosely by an author to characterize a judgment that the author disagrees with. More often than not is used by way of reprimand rather than by way of approval. I think the term can be more accurately used by reference to specific criteria. It may refer to judicial review. According to this criterion, a court is active where it enhances its own powers vis-à-vis the powers of the other branches of government. In that sense, every time a court invalidates an administrative measure or a legislative measure, it gives preference to its own internalized notion of justice, to its own interpretation of the Constitution vis-à-vis the preferences of the other branches of government. Secondly, judicial activism can be defined by reference to the rules of interpretation. According to this criterion, where a court departs from the language of the law, the more it departs from a literal interpretation, the more active it becomes. Thirdly, judicial activism can refer to a court's approach towards its own precedent, and I'm referring here to courts which are at the apex of their jurisdiction. In that sense, the more a court is willing to depart from precedent, the more active it is, and vice versa. A court which is reluctant to depart from stare decisis exercises restraint. So how does the ECJ fare in relation to those three criteria? Let me make the following remarks. First, I don't think it is correct to say that the European Court of Justice is a political court. A constitutional court, and I think it is fair to describe the ECJ as a constitutional court, because of the nature of its jurisdiction, may deliver judgments which bear political repercussions. By political, I do not mean partisan. I mean that judgments may have consequences which go well beyond the interests of the parties to the litigation and affect the community as a whole. A judgment may be political because it affects the allocation of public resources, as for example, when a court decides that a benefit should be granted without discrimination on grounds of gender, nationality, or sexual orientation. A judgment may also be political because it may affect the allocation of competencies between the European Union and the member states, or it may impact on a matter of state security or affect a high constitutional value, as, for example, when the right to life and the prohibition of abortion may clash with a commercial freedom, such as the freedom to provide services, or a constitutional right, such as the freedom of speech or the right to privacy. So the fact that the European Court of Justice delivers judgments on such issues is no more than an inevitable reflection of its jurisdiction. Its judgment would be political, whatever the outcome. Secondly, I think it is incorrect to suggest that the teleological method of interpretation, one which is guided by the objectives of the law, is somehow inappropriate. It is well recognized as one of the established methods of interpretation by the Vienna Convention on the Law of Treaties and practiced also by national courts. It is particularly appropriate where the provisions of written law are vague and indeterminate and bestow the court with unusual power to shape the direction of the law. This is in fact the case with the provisions of the EU treaties, which remain framework provisions, often highly indeterminate and ambiguous in their terms. This is not to say that the court should pay no respect to the language of the law, or that it is always a good idea to follow a purposive interpretation. It is a question of degree and an assessment to be made within the specific factual and legislative framework. One may agree or disagree with the judgment and the reasoning of a court, but it is incorrect to question the legitimacy of the European Court of Justice on the ground that it follows a purposive interpretation of the treaties. A measured and, whatever my view is worth, a correct critique towards the teleological interpretation followed by the European Court of Justice was expressed by the Supreme Court of the United Kingdom in a recent case on the HS2 railway. The case concerned environmental law and brought to the fore a clash between constitutional principles, i.e. the principle of environmental protection as it is understood in EU law, and the principle of parliamentary privilege, which is enshrined in the Bill of Rights. Nor is it correct to say that the European Court of Justice always favors integration, or that it follows an unwarranted interpretation of free movement rights. It is correct that there is a strong pro-integration bias in the case law, but I think this reflects the intention of the treaties. Two judgments, I think, may serve to illustrate the point that the approach of the court is in fact more balanced than it is sometimes made out to be. One is a judgment in a case called Dano, the other is a judgment in a case called Alemo-Heron. In Dano, the court took a restrictive interpretation of the rights of migrants from other EU states, but it did not appear to make the news. It is a case which, in many respects, puts on the brakes to free movement provisions of the treaty, or at least for those migrants who are not economically active. Alemo-Heron is a case where the European Court of Justice takes a narrow view of workers' rights and provides for a noticeably pro-market approach. It is true that the reasoning of the European Court of Justice can be obscure and incomplete. Mr. Justice Lewison stated in a case that discerning shifts of emphasis in successive decisions of the European Court sometimes resembles the finer points of criminology at the height of the Cold War. But is this elegant aphorism correct? Does it stand to scrutiny? It is correct to say that the reasoning of the court unravels within the confines of a collective judgment. It lacks the flair, the clarity, the thoroughness of the reasoning of individual, concurring or dissenting judgments or of the common law. If one had all the choice in the world, one would probably build the EU legal system starting from common law standards. It would opt for a streamlined, small common law court. But legal systems are not designed in lecture rooms. They are untidy, they are messy, they remain to a good extent prisoners of tradition, and their evolution is subject to the vicissitudes of the political game. So this is what we have. Still, the difference between common law judgments and those of the European Court of Justice can be exaggerated. Not all common law judgments are clear. Let me take an example from a judgment of the House of Lords, a speech delivered by the late Lord Slynn. The case, the Henley case decided back in 2003, has to do with strict liability for the behavior of dangerous animals. And Lord Slynn stated as follows: the purpose of the legislation is, subject to specific exceptions, to impose strict liability for dangerous animals, but to distinguish between normal and abnormal behavior for non-dangerous animals. Well, so far so good. What is normal has to be considered, one, as a general rule, and two, as an event in particular circumstances. The object of the provisions, as I see it, is to exclude strict liability not only for behavior which is normal in the normal circumstances, but also behavior which is normal in particular, i.e. abnormal circumstances, even if such behavior would be abnormal in normal circumstances. There is thus strict liability for abnormal behavior in normal circumstances and also for behavior which is abnormal in normal or particular circumstances, subject, of course, to paragraphs A and B being satisfied. I do not think that the words used are intended to convert what is normal in abnormal circumstances to being abnormal in those circumstances, because it will be abnormal in normal circumstances. And you thought nuclear physics was difficult and law was easy. In fact, the text makes perfect sense. It is not only elegantly written, but if one were to spend some time, one would find that it makes for a fine interpretation of the statutory provision. What is the conclusion? I think the conclusion is that if you are a member of the Supreme Court, you can say what you like, but also that law is very difficult, and the job of the judges is extremely intricate. I do think, though, that sometimes we exaggerate the difference between common law judgments and those of the European Court of Justice. Not all common law judgments have the clarity one might wish for. It is not unheard of to have plurality opinions, judgments where there is a result as to there is a majority as to the result, as to the outcome, but the individual judges who form the majority reach the outcome on the basis of different reasoning. So I think what we have experienced in European Union law is the birth of common law by uncommon judges. They speak and write in French, but which is the working language of the court, but they think in English. This idea of a common law constitutionalism, the idea, in other words, that we resolve controversial questions of constitutional law not only by looking at the text of the Constitution or the treaty, but also on the basis of precedents or on the basis of fairness, of good policy, is not by any means unfamiliar to the judges. If one looks back at the common law and the way it developed, it was concerned not only with judicial precedents, but also with legislation, with custom, even general trends in society. All of them were part of the law of the sources that common law judges considered. Also, unpopular judgments are by no means the prerogative of the ECJ. Constitutional courts come and should come under scrutiny. One can think of many unpopular judgments delivered, for example, by the United States Supreme Court. One that comes to mind is a case decided in 2010, Citizens United, where the court invalidated on grounds of free speech a part of the Bipartisan Campaign Reform Act, even though the act had, it appears, very wide popular support. So I think it is good to remind ourselves that a good constitutional order has different elements. Some of them are highly responsive to popular opinion, others are designed to be less responsive. As Professor Strauss of Chicago Law School mentioned, any plausible constitutional system is to some degree undemocratic. So the correct question is not to ask, is the ECJ being an activist? The correct question to ask is, what makes a good court? And it seems to me that a good court is one which satisfies the following criteria. It must be embedded in a democratic system. It must deliver judgments supported by compelling reasoning. The judgments must be delivered in good time. They must be fair, and they must reflect, to a degree, the sentiment of the constituent parts of the polity. In the case of the European Union, the member states and the individuals, in particular, I would argue, the individuals. So, conclusion. But my first conclusion is unoriginal, but that does not make it any less important. It seems to me commitment to fundamental rights is a sine qua non for democracy. We need more, no less, human rights protection. I accept that there is a possibility that fundamental rights may be abused. But if we accept that fundamental rights may be abused, surely we must also accept that public powers may be abused. I ask you to consider, under what constitution would you rather live? One which makes it easy for the government to abuse its powers, or one where the courts remain vigilant in the name of human rights? Lest we forget, historical experience teaches us that regression is possible. The acquis of constitutionalism cannot be preserved without vigilance and effort. Secondly, I think the influence of European Union law on our legal system is not to be viewed with consternation, but as an enrichment to our legal tradition. I think this applies to all member states of the European Union. Thirdly, I believe that the legitimacy critique leveled against the European Court of Justice is not persuasive. I am prepared to take issue with specific judgments, but I do not consider that the court in any way exceeds the bounds of its legitimacy. Finally, whilst the European Court of Justice has done much to contribute to the protection of fundamental rights, in my view, it has erred too much on the side of EU competence by elevating every dispute pertaining to the competence of the European Union to an existentialist dispute. Somehow, the court appears to think that if there is judicial review, this suffices to protect the rights of the individual. But I think this dual standard, high protection of fundamental rights, low standard of scrutiny when it comes to EU competence, gives an illusion of disconnection. The two are in fact closely connected. A high standard of judicial review does not suffice to protect the rights of the citizens. By way of an epilogue, allow me to say one word and to pay tribute to Sir Francis Jacobs. He has been really at the very heart of the Center of European Law. Francis Jacobs, the Advocate General, the professor, the mentor, the friend. I think the Center would not be what it is without Francis. Thank you very much for listening. Takis, stay here a second. Yes.
In the decades of the 1960, in the decade of the 1960 when I grew up, there was somewhat of a disdain for ceremony, and some academic ceremonies fell to the side. It was as though the world was to be born anew. And that has never been my preference, never my approach. And I think here we keep great pleasure and joy in welcoming our students at the start of their studies. We celebrate their graduation. We mark these events that define our shared humanity. And for many of us, Takis, it is our pleasure to participate in an inaugural lecture. A professor is someone whose grasp of a substantive field is so deep, so complete, that he or she can profess, can declare, and hopefully entertain. And you have given us a marvelous example of that this evening, and it is much appreciated. Takis's magisterial work is the general principles of EU law, and it has an opening epigram. It is appropriately drawn from Plato's Republic, and it is appropriately but difficultly for me in Greek. But in one translation, it reads, "Justice will be what remains once they find the other three virtues in it, namely wisdom, courage, and moderation." Professor Tridimas reminds us that these virtues, namely wisdom, courage, and moderation, are virtues of a just Europe. I also observe that they are the virtues of a great scholar. So please join me in welcoming to King's College Professor Takis Tridimas, thanking him for this inaugural lecture, and appreciating in our midst a great scholar. Thank you.